In Tennessee, I got to show that you were aware that your conduct was reasonably certain to cause death. So what the prosecutors are going to face over there at trial, if this thing goes to trial, is the defense is going to be, you can't establish, of course, we're not disputing that Tyre Nichols died as a result of the beating. But what was in second-degree murder is a crime of it's a mental crime. What was in your head? That's what distinguishes second-degree from first-degree murder. The prosecutors are going to have to prove that these cops were aware that what they did were reasonably certain to cause death. And this is where the whole trial flips on its head. Where in Nevada, I could use their behavior after the fact to say they acted with depraved indifference to humanity. I could see a defense attorney being in Tennessee going, their behavior after the fact showed that they were not reasonably certain that what they just did was going to cause his death. They thought they had just beat a man. They thought they beat him up. They didn't think he was going to die. So that's really the defense out there. And if that defense is successful, the lesser included offense that's going to be there for the jury to deliberate on at trial is reckless homicide. And that means instead of acting knowingly, and this is me as a defense attorney, if I'm up there having to defend these guys, which I would never want to do, but if I did, I'd say they acted recklessly. Okay. We're not disputing that Tyre Nichols was killed, and we're not disputing that these guys need to be convicted of a crime, my client, but they didn't act knowingly. They weren't certain that he was going to die. Recklessly means a person is aware of, but consciously disregards a substantial and unjustifiable risk that the alleged victim is going to be killed. It's a gross deviation from the standard of care that a normal person would exercise when you're viewing it from the accused person's standpoint. Man, I almost fell asleep just saying that. It took me back to my law school years. But what does that mean? It means this. I'm aware that there was a risk that the victim was going to die, and I consciously disregarded that risk. But I wasn't reasonably certain that what I just did was going to kill him. Do you see how that defense could be viable at a trial? Because here, as a prosecutor, they have to convince every single one of those jurors, 12 jurors, beyond a reasonable doubt, that they're guilty of second-degree murder. That every single one of these officers knew, that they were aware that what they just did was reasonably certain to cause Tyre Nichols' death. And when they only need one, and the defense only needs one juror to say, I'm not convinced that they were reasonably certain to cause his death, that what they just did. I'm not convinced that beyond a reasonable doubt about that, but I am convinced beyond a reasonable doubt that they were aware of that there was a risk that he was going to die and that they consciously disregarded that. I could definitely get on board with that. So if you have 12 jurors agreeing on reckless homicide and only 11 jurors agreeing on second-degree murder, guess what? The conviction is going to be reckless homicide. So that is a worry for me in this prosecution for second-degree murder, that these guys can come out with a reckless homicide conviction, which is going to have a substantially lesser sentence, a range one sentence.